Hello everyone, welcome to MAYANK LAWHOLIC. In this video, we will discuss the 2017 Delhi Higher Judicial Service paper. Before we start, it is my humble request, please subscribe to our channel MAYANK LAWHOLIC and also join our Telegram channel, the link of which is provided in description section. So let's get started from question number 1. National Film Award for the Best Feature Film in 2018 was awarded to, here the correct answer is Village Rockstar. This question is related to current affairs in 2018, but for 2021 is Malayalam film Marakkar, Lion of the Arabian Sea. Now let us see the question number 2. Prime Minister of Nepal is. The options are Thagda Prasad Oli, Pushpa Kamal Dahal, Bisheshwar Prasad Koirala, and 4. Sushil Koirala. In 2018, at that time, KP Oli was the Prime Minister of Nepal, but right now, Sher Bahadur Deuba is the PM of Nepal at present in 2021. Now let us see the question number 3. Kaveri originates in. The correct answer is Karnataka. Kaveri is the very important river which originates from Karnataka. In question number 4, in April 2018, the leaders of North and South Korea, Kim Jong-un and Moon Jae-in, held the meeting in. Options are Panjim, Wonsan, Hamburg and Kaesong. The correct answer is Panjim. In April 2018, leaders of North and South Korea met in Panjim. Now let us see the question number 5. Which former Malaysian Prime Minister was recently barred from leaving Malaysia? Here the correct answer is Najib Razak. Najib Razak was the Prime Minister of Malaysia who was barred from leaving Malaysia. Now let us see the question number 6. Which one of the following will soon come out with the development agenda for a new India by 2022? First, SEBI, second, Niti Aayog, third, Reserve Bank of India and fourth, NABARD. Here the correct answer is second, Niti Aayog. Present Lok Sabha is the 13th Lok Sabha, 14th Lok Sabha, 15th Lok Sabha or 16th Lok Sabha. Here the correct answer is 16th Lok Sabha. Present Lok Sabha is 16th Lok Sabha. Question number 8. New York's Attorney General who resigned in 2018 after allegation of sexual abuse against him. Eric Schneiderman, Jeff Sessions, Harvey Weinstein and Alberto R. Gonzalez. Correct answer is Eric Schneiderman. Question number 9. The precautionary principle relates to. Options are motor accident claims, second, criminal law, third, environment law, fourth, copyright law. Here the correct answer is environment law. Precautionary principle means if there is a risk of severe damage to humans and environment in absence of incontrovertible conclusive or definite conclusives, precautionary principles enables decisions makes to adapt precautionary measures when scientific evidence about an environment or human health hazard is uncertain and the stakes are high. In how many languages is the denomination written on the Indian currency note? Options are 10, 9, 17 and 12. Correct answer is 17, including English and Hindi. In total 17 languages, the denomination written on the Indian currency note. Now let us see the question number 11. In 1885, first session of Indian National Congress was held in. Options are Ahmedabad, Calcutta, now named Kolkata, Bombay, now named Mumbai and fourth, Delhi. Here the correct answer is Bombay, now named Mumbai. On 28 December 1885, in Bombay, Gokul Das Tejpal Sanskrit College with 72 delegates, the first session of Indian National Congress was held. Now let us see the question number 12. Which among the following was the brain behind the Chittagaon Armory raid in 1930? Options are Lala Hardayal, Subhash Chandra Bose, Surya Sen and Chandrasekhar Azad. Here the correct answer is Surya Sen. Revolutionary Surya Sen was commonly known as Master Da. There is one movie of Abhishek Bachchan which was based after the Chittagaon Armory raid in 1930, which was related to the revolutionary Surya Sen. Now let us see the question number 16. Which supersonic cruise missile did India successfully test fire at Pokhran in March 2018? Options are Shaurya, second BrahMos, third Agni and fourth K4. The correct answer is BrahMos. Now let us see the question number 14. Which of the following is not a member of the Association of Southeast Asian Nation, ASEAN? Options are Myanmar, Sri Lanka, Singapore, Brunei. Here the question is asked which of the following is not a member of the ASEAN. So correct answer is Sri Lanka. Sri Lanka is not the member of ASEAN. ASEAN is known as the Association of Southeast Asian Nations. Total 10 members are in ASEAN. ASEAN was founded on 8th August 1967 at Bangkok, Thailand. 10 member nations I have already said. Members are Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Philippines, Singapore, Thailand and Vietnam. In 1992, India became sectoral dialogue partner. In 1995, India became full dialogue partner. In 1996, India became member of ASEAN Regional Forum. For India, related to Act East policy, ASEAN is very important. ASEAN is very important organization because India want to have a comprehensive dialogue for trade and other benefits, and the foreign policy of India related to Act East policy is very much comprehensively depend upon the ASEAN countries. Now let us see the question number 15. What is the present sanctioned strength of judges including Chief Justice in the Supreme Court of India? Options are 31, 33, 35 and 37. Here the correct at that particular time in 2017 the correct answer was 31, but right now the correct answer will be 33, because at right now in 2022 the correct strength of sanctioned strength of judges including Chief Justice of India, Supreme Court of India, the sanctioned strength total judges are 33 judges. Now let us see the question number 16. The International Day of Person with Disabilities is celebrated on 1st 3rd December, 2nd 8th March, 3rd 13th November, 4th 1st June. Here the correct answer is 2nd 8th March. On 8th March, International Day of Person with Disabilities is celebrated. Question number 17. Usury laws are statutes that prohibit wagering, statutes that prohibit finance charges above a certain level of debt, statutes that prohibit illegal use of land, statutes that prohibit illegal use of public money. In this question, the correct answer is second, statutes that prohibit finance charges above certain level of debt. Now let us see the question number 18. Match the two columns. Option 1, Neeru Chadda. Option B, C.B. Muthamma. Option C, Sarojini Naidu. And option D, Vijayalakshmi Pandit. Here the correct answer is option A, Neeru Chadda, Judge International Tribunal for the Law of Sea. C.B. Muthamma. Here the correct answer will be first female to join the Indian Foreign Service. Sarojini Naidu became the first governor of an Indian state. Vijayalakshmi Pandit, President UN General Assembly. AILET means metal or plastic tube fixed tightly round each end of shoelace, ankle support, baby bird, the blunt edge of knife. Here the correct answer is metal or plastic tube fixed tightly round each end of shoelace. Question number 20. The word which is wrongly used in sentence is known as, correct answer is malapropism. Philtrum means the vertical groove between the base of the nose and the border of the upper lip. Question number 22. The wages of sin is death. 5,000 rupees is not a bad salary. The two sentences above can be correctly written as. In this question, the correct answer is option first, with no change. They are already correctly written. Now let us see the question number 23. The war caused both death and destruction and generations of hatred between the two communities. Without changing the meaning, the above sentence can be transformed as option 1. The war had caused both death and destruction as there was generations of hatred between the two communities. The war would have caused death, destruction and generations of hatred between the two communities. Option 3. The war would not only cause both death and destruction but also generations of hatred between the two communities. Option 4. The war was the cause of death, destruction and generations of hatred between the two communities. In the given option, the correct answer will be option number 3. The war not only caused both death and destruction but also generations of hatred between the two communities. Now let us see the question number 24. They sat dash him dash being fined they were imprisoned. Her answer is dash the point. The correct prepositions to be filled in the above sentences in order are. Options are beside, besides, beside. Second option beside, besides, besides. Third option besides, beside, besides. And fourth option beside, beside and besides. In this question the correct answer is option number 2. They sat beside him besides being fined they were imprisoned. Her answer is besides the point. This is the correct answer. Now let us see the question number 25. Science has lost its capacity to enlighten ordinary citizens as it has become so intricate and esoteric that only the masters of specialisms within scientific disciplines can follow selected pathways through science knowledge mazes. Which of the following best expresses the essence of the above sentence? Option 1. Science is a subject difficult to understand. Specializations in science have made it abstruse. Science is full of knowledge mazes. Specialization in science have made it unfathomable for the common people. Here the correct answer in this question is option number 4. Specialization in science have made it unfathomable for common people. Now let us see the question number 26. The feminization of teaching and nursing had occurred because such work was seen as extension of the nurturing work that women do within home. Which of the following best describes this statement? An analysis of women's majority in teaching and nursing, a description of teaching and nursing profession, a compliment to women as nurturers, an ironical take on teaching and nursing. In this question, The correct answer is option 1, an analysis of women's majority in teaching and nursing. Now let us see the question number 27. Question number 27 is related to the passage. Read the following passage and answer the question from 27 to 31. They had been camping in this part of Africa, undergoing exercise to familiarize themselves with the African war in grasslands and small dense forests, where the rule was fire first and apologize afterwards. In this land of swamps, they lived among large mosquitoes that outnumbered them by 1,000,000 to 1. There were deaths from malaria. The condition of the white troops was worse, because they fell victim not just to malaria but to diarrhea and skin diseases as well. Many died without firing a shot. Question number 27. Swamp means options are forest, marshes, hilly regions or river. In this question, correct answer is marshes. Swamp means marshes. Question number 28. They need to familiarize themselves because Africa is a difficult terrain. There are many forests in Africa. They have to kill mosquitoes. They are not used to the terrain. Correct answer is option 4. They are not used to the terrain. Fire first and apologize afterwards indicates they don't care for consequences. Their lives would be in danger if they did not fire. They are unapologetic. They have to learn to apologize. Here the correct answer is their lives would be in danger if they did not fire. How many die without firing a shot? Option 1, they were killed by diseases. Option 2, they were killed by their enemies. Option 3, they died because of tough terrain. And option 4, mosquitoes killed them. In question number 30, correct answer is option 1, they were killed by diseases. Exercises implies sports, running, military exercises, fitness training. Here the correct answer is military exercises. Read the following passage and answer the question from 32 to 36. At the end of the 20th century, we were living in a world saturated with music. Sounds accompany us everywhere, and particularly when we are waiting in closed spaces, whether on telephone, on an aircraft or at the hairdressers. The consumer society seems to consider silence a crime. So music has nothing to fear in the 21st century. Admittedly, it will sound quite different by comparison with the 20th century. Present day world has already been fundamentally revolutionized by electronics, which means that it is already largely independent of inventive talent and technical skill of the artistic individual. Question number 32. Revolutionized means made independent, made more interesting, radically changed, used for revolution. Correct answer is radically changed. According to the author, music in the 21st century is more blaring, is not pleasant, has become more popular, is more electronic and less dependent on individual talent. Here the correct answer is more electronic and less dependent on individual talent. The consumer society seems to consider silence a crime, is irony, insulting comment, angry reaction and satiric comment. Correct answer is satiric comment. Question number 35. 21st century society is characterized as more interested in music, revolutionary, consumerist, closed. Correct answer is consumerist. Inventive means angry person, a person who makes inventions, artist, creative. Inventive means a person who makes inventories. Now let us see the question number 37. B is a person of unsound mind. A hands over a petrol-soaked piece of cloth afire to him and instigates him to throw it into the car of C. B complies. As a result of the car is destroyed in fire. A and B are prosecuted on the charge for offense of mischief. Here, both A and B are guilty because the acts committed show they had agreed to an illegal act. Only B is guilty because A had not set the car on fire. Only A is guilty because he instigated B to commit the act. Both are not guilty because B did not have the mens rea and A is not responsible for actus reus. Answer will be option 3. Only A is guilty because he instigated B to commit the act and B is the person of unsound mind. So B will not be the guilty. B will come under the exceptions of IPC. Now let us see the question number 38. A has engaged in services of B, a financial planner, to make investment on his behalf. A remits rupees 10 lakhs to B, asking him to purchase stocks in company X. B, finding investment in company Y to be possibly more lucrative, invests the money in purchasing its share. Company Y goes into liquidation, resulting the losses. Here, B is guilty of the criminal breach of trust. B is guilty of dishonest misappropriation. B is guilty of cheating. B has not committed any offense. Correct answer is option 4. B has not committed any offense. Now let us see the question number 39. In someone's case instituted otherwise than upon a complaint, where the Metropolitan Magistrate stops the proceeding under section 258 CRPC after the evidence of principal witness has been recorded, he may, option 1, release the accused, and such release shall have the effect of discharge, pronounce a judgment of acquittal, either discharge or acquit the accused, discharge the accused only on the request of the accused or his counsel. Correct answer is pronounce judgment of acquittal. This question is related to section 258 of CRPC. Section 258 of CRPC says about power to stop proceedings in certain cases. In any summon case, instituted otherwise than upon complaint, a magistrate of the first class or with the previous sanction of CJM, any other judicial magistrate may, for the reasons to be recorded by him, stop the proceedings at any stage without pronouncing any judgment, and where such stoppage of proceedings is made after the evidence of the principal witness has been recorded, pronounce a judgment of acquittal, and in any other case release the accused, and such release shall have the effect of discharge. So option second is the correct answer. An accused can be examined as a witness for the defense and give evidence of a trial under section 315 CRPC only where option 1 the accused makes an oral request that he be examined as a witness. Option 2 both the accused and his counsel make an oral request that the accused be examined as a witness. Option 3 the accused himself makes a written request that he be examined as a witness. Option 4 when the court feels that there is substantial evidence against the accused and therefore the accused must lead evidence. Here the correct answer is the accused himself makes a written request that he be examined as a witness. Section 315 of CRPC says accused person to be competent witness. Option third is the correct answer. Now let us see the question number 41. Which of the propositions is not correct with regard to the period of limitation specified in section 468 CRPC for taking cognizance? Options are the period of limitation is 6 months for offences punishable with fine only. Option second, the period of limitation is 1 year for offences punishable with imprisonment for a term not exceeding 1 year. Option 3, the period of limitation shall be 3 years if the offence punishable with imprisonment for a term exceeding 3 years. And option 4, the period of limitation in relation to the offences tried together is determined with reference to the offence which is punishable with the most severe punishment. Here the correct answer is option number 3. The period of limitation shall be 3 years if the offence is punishable with imprisonment for a term exceeding 3 years. Section 468 of CRPC tells about bar to taking cognizance after lapse of period of limitation. Now let us see the question number 42. Which of the following acts done by the Metropolitan Magistrate while not being empowered by law is not an irregularity vitiating the proceedings under the section 461 of CRPC? Tries an offence summarily, tries an offender, demands security for good behavior, pardons the offender. Here the correct answer is option 4, pardons the offender. Section 461 CRPC tells about the irregularities which will vitiate the proceedings. Now let us see the question number 44. Which one of the following is not a class 2nd heir as per schedule to the Hindu Succession Act 1956? Options are daughter's son's son, option second daughter's son's daughter, and option 3 father's father, and option 4 daughter's daughter's son. Here the correct answer is option 3, father's father will not be the class 2nd heir as per the schedule to the Hindu Succession Act 1956. Now let us see the question number 45. A will is proved by filing and proving the original will. There are however exceptions to this rule. Which of the following exception is correct? Options are: if the original will is destroyed by the testator, then a certified copy of the registered will can be produced and proved. Second option is where the will has been torn by the testator, but before tearing the will, he has given a copy of the will to each of the beneficiaries and one of the beneficiaries produced the said copy. And option 3, if the original will is lost by accident after death of the testator and a copy is produced by one of the beneficiaries. Option 4, if the original will was revoked but was on a non-judicial stamp paper and signed by the two witnesses, then any one of the said two witnesses can produce and prove a photocopy of the will. In question number 45, the correct answer is option 3rd. If the original will is lost by accident after the death of the testator and a copy is produced by one of the beneficiaries, probate of a will is compulsory in Delhi. If the will is executed in Delhi for immovable properties situated outside Mumbai or Kolkata or Chennai, if the will is executed in Delhi and properties are located in NCR of Delhi. Option 3, if the will is executed in Delhi and the will appoints an executor under section 222 of the Indian Succession Act. And option 4 is not a correct statement. In this question, none of this statement is the correct statement. An ex parte letters of administration granted with respect to a will can be revoked. Option 1, only under section 263 of the Indian Succession Act. Option second, can never be revoked. Option 3, only when conditions of Order 9 Rule 13 CPC are satisfied because section 263 of the Indian Succession Act does not apply. And option 4, none of the above. In this question, correct answer is option 1, only under section 263 of the Indian Succession Act as an ex parte letters of administration granted with respect to a will can be revoked. Now let us see the question number 48. Probate or letters of administration granted by the district judge in one state will have operation throughout the country with respect to all properties wherever situated. Option 1, yes, provided the judgment of the district judge is upheld by the High Court in an appeal. Option second, yes, if the value of the properties estate outside the territorial jurisdiction of the district judge do not exceed sum of 2 crores. And option 3, yes, if the value of the properties outside the territorial jurisdiction of the district judge granting probate do not exceed a sum of rupees 10,000. And option 4, yes, provided there is a notification by the central government that the judgment of the district judge will apply throughout the territories of India. In this question, the correct answer, option 3, yes, if the value of properties outside the territorial jurisdiction of the district judge granting probate do not exceed the sum of rupees 10,000. Now let us see the question number 49. Ceremonies of Hindu marriage: B, Sapinder relationship, C, void marriage, and D, voidable marriage. Ceremonies of Hindu marriage, section 11 of the Hindu Marriage Act. Sapinder relationship is provided in section 5 of the Hindu Marriage Act. Void marriage is provided in section 7 of the Hindu Marriage Act. Voidable marriage are provided in section 12 of the Hindu Marriage Act. Question number 50. Where the wife files a petition for restitution of conjugal rights under section 9 of Hindu Marriage Act 1955, on whom lies the burden of proving reasonable excuse for withdrawal from the society? Options are petitioner wife, respondent husband, family members of the wife, family members of the husband. Here the correct answer is option number 2, that is respondent husband. This is the correct answer, respondent husband. Now let us see the question number 51. Match the names of the cases in the core issues. A, Geeta Hariharan and another versus Reserve Bank of India, AIR 1999. B, Srimati Sarla Mudgal, President Kalyan and others versus Union of India and others, 1995. C, Hiralal P. Harsora and others versus Kusum Narottam Das Harsora and others, AIR 2016. D, Daniel Latifi and another versus Union of India, AIR 2001. Here the correct match will be for option A, Geeta Hariharan and another versus Reserve Bank of India. Correct match is guardianship. For option 2, Srimati Sarla Mudgal, President Kalyan and others versus Union of India and others, AIR 1995. The correct match is conversion for marriage. Option C, Hiral P. Harsona and others versus Kusum Narottam Das Harsona and others, AIR 2016. For this question, correct answer is domestic violence. And the last, Daniel Latifi and another versus Union of India. Correct match is maintenance, D. Now let us see the question number 52. In divorce proceeding, a decree for judicial separation by way of alternate relief under section 13A of Hindu Marriage Act 1955 cannot be passed where the relief sought is under. Options are section 13 subsection 1 clause A of the Hindu Marriage Act 1955, cruelty. Option 2, section 13 subsection 1 clause 2 of Hindu Marriage Act 1955, conversion to another religion. And option 3, section 13 subsection 1 clause IB of the Hindu Marriage Act 1955, desertion. And option 4, section 13 subsection 2 clause 2nd of the Hindu Marriage Act 1955, husband guilty of rape, sodomy or bestiality. Here the correct answer is option number 2, that is section 13 subsection 1 clause 2 of Hindu Marriage Act 1955, conversion to another religion. Question number 53. The Hindu Marriage Act 1955 is applicable to first, A Jain and B Buddhist, both having domicile in Sikkim and working in United Kingdom. Option 2, C a Sikh, D a Hindu, both having domicile in United Kingdom and working in Sri Lanka. Option 3, G and H, both Hindus having domicile in Bhutan and working in the United Kingdom. Fourth, all of the above. The Hindu Marriage Act 1955 will be applicable. Jain also comes into the category of Hindu related to Hindu Marriage Act, and Buddhist also. They have a domicile in Sikkim, which is in India only, and they are working in United Kingdom. They have the domicile of Sikkim. It means that Hindu Marriage Act will be applicable to them. Right now they are working in the United Kingdom. But in the other options, the domicile is United Kingdom, and here the domicile is Bhutan, which is not the territorial jurisdiction of India. Therefore, the correct answer will be option 1, A Jain and a B Buddhist, both having domicile in Sikkim and working in United Kingdom. Now let us see the question number 54. Which of the following included within the degrees of prohibited relationship under the Hindu Marriage Act 1955? First option, lineal ascendant of the other. Second, wife or husband of lineal ascendant or descendant of the other. Option 3, children of two sisters. And option 4, all of the above. In the given options, all options are correct. Fourth will be the right answer. Now let us see the question number 55. No tax without authority of law is a principle embodied under the article of the Constitution of India. Options: Article 226, Article 32, Article 245 and Article 265. Correct answer is Article 265, which says that tax is not to be imposed save by authority of law. No tax shall be levied or collected except by the authority of law. Question number 56. Is a writ petition maintainable against an order passed by the Supreme Court on the judicial side? If so, under which article of the Constitution of India? Options are yes under Article 32, yes under Article 226, yes under Article 32 as well as Article 226. No, the petition is not maintainable. In this question, correct answer will be option 4. Writ petition will not be maintainable in this case. Now let us see the question number 57. A foreigner applied for a job with a state enterprises. Her application was rejected summarily on the ground of religion and place of birth, despite the fact that advertisement had no such criteria stipulated therein, which article of the Constitution of India can she take recourse to? Options are Article 15, which prohibits discrimination inter alia on the ground of religion and of place of birth. Article 16, which allows equality of opportunity in matters of public employment. And Article 14, which guarantees the equality before law. Option 4, none of the above. In this question, correct answer is option 3rd, Article 14, which guarantees the equality before the law, because here the foreigner has applied for the job, not the Indian citizen. In case of Indian citizen, the guarantees of fundamental rights will be implemented more comprehensively. Question number 58. Parliament, in exercise of power under Article 368, makes a law which does away with the fundamental right conferred under Article 15 of the Constitution of India. The executive seeks to defend the challenge instituted in court based on the clause 4 of Article 368, which prohibits such action being questioned in court on any ground. Can the challenge in this court be sustained? Option are no, the challenge if made in a court action cannot be sustained. Challenge is sustainable. The only remedy lies in bringing a fresh amendment. And option 4, none of the above. In the question number 58, correct answer is second, challenge is sustainable, and Article 368 is related to the amendment of the Constitution. Question number 60. A person who is a businessman continues in preventive detention under a law enacted by the state without the matter being referred to the advisory board, which is the most appropriate provision of the Constitution of India. He should take recourse to option 1, Article 19, subsection 1, clause G, Article 20, Article 22, none of the above. In the question number 60, the correct answer is Article 22. Article 22 says that because of Article 22, it will be the infringement of fundamental rights. So Article 22 will be implemented, and Article 22 states that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now let us see the question number 61. When a contract is broken, there can an aggrieved party sue only for losses or damages which naturally arose out of breach, and also for the losses or damages which are a result of breach of contract. In view of the statement, which of the following is correct? Options are all the types of losses or damages can be claimed. Option second, all type of losses or damages can be claimed only if the contract is registered under the Registration Act. And option 3, only damages can be claimed which naturally arose from the breach unless notice of losses or damages not directly arising out of the breach which was known to the person guilty of the breach of contract. And option 4, normal damages which arise directly from the breach and special damage which are not in contemplation of the party when the contract was made, both can be claimed provided when there is a breach of contract, a public notice is given by the aggrieved party of the special loss suffered. In this question, the correct answer is option 3, that is only those damages can be claimed which naturally arose from the breach unless notice of losses or damages not directly arising out of the breach known to be the person guilty of the breach of contract. This is the correct answer. Question number 62. Is it an absolute proposition of law that in a contractual relationship of a principal and an agent, a principal is always bound by the acts of the agent, and an agent takes no rights or incurs no personal liability under a contract entered into him as an agent of the principal with the third person? Options are no, an agent is personally and jointly and severally liable in all contracts. Option second, no agent will be personally liable only when he does not disclose the name of his principal or when the name is disclosed but the principal cannot be sued for reasons provided in law. And option 3, no, an agent will be personally liable if the principal has expired in view of the Legal Representation Act. And option 4, none of the above. In this question, the correct answer is option second, that is no, an agent will be personally liable only when he does not disclose the name of his principal or when the name is disclosed but the principal cannot be sued for reasons provided in law. Now let us see the question number 63. When will it be permissible to exclude the time spent of the pendency of an earlier suit for computing the period of limitation for filing a subsequent suit? Options are if the earlier suit is filed in a court lacking precautionary jurisdiction, if the earlier suit is filed in a court lacking territorial jurisdiction, if the earlier suit filed in a court which lacks subject matter jurisdiction. Option 4, all of the above. Here the correct answer is option 4, all of the above. Question number 64. Is it correct that a fresh period of limitation commences from the payment made on account of debt after the expiry of period of limitation? Options are no, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation, but provided that the acknowledgement of payment only appears in the registered document. Option second, no, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation, provided acknowledgement of payment appears in handwriting of or in writing signed by the person making the payment. And option 3, if the payment after expiry of period limitation is on account of debt and accompanied by a court order condoning delay in making payment after the expiry of the period of limitation. Option 4, none of the above. In this question, the correct answer is option 2. No, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation and provided acknowledgement of payment appears in handwriting of or in writing signed by the person making the payment. This is the correct answer. Now let us see the question number 65. The period of limitation to set aside a sale of execution of a decree under Article 127 of Schedule of the Limitation Act 1963 from the date of the sale is option A 30 days, 90 days, 60 days or 10 days. In this question, the correct answer is option number 3, that is 60 days. Question number 66. When a new party to a suit is added, then can the suit qua the party be taken to be instituted from the original date of filing of the suit? Option R. No, the suit is taken as filed by or against a party only when the order impleadment is made. No, the suit is taken as filed by or against party only after the date of filing of the application or for impleadment. Yes, it is correct provided that the court is satisfied that the omission to implead the person was due to a mistake in good faith. Yes, provided that when the suit was originally filed, it was filed on behalf of a minor and who after becoming a major pendent light ratifies the filing of the suit from the original date. In question number 66, the correct answer is option 3, which says that yes, it is correct provided that the court is satisfied that the omission to implead the person was due to a mistake of good faith. Question number 67. On 1/1/2010, an amount is deposited by the plaintiff with the defendant not being a loan. On 1/1/2012, demand is made by the plaintiff for repayment of the deposit. On 1/1/2014, suit for recovery is filed for the amount of deposit. Is suit within the limitation? Options are: the suit filed on 1/1/2014 is time barred as it is filed 3 years after having made the deposit on 2010. The suit filed on 2014 is within limitation because limitation of 3 years commences on 2012. Option 3, neither 1 nor 2. And option 4, the suit is not time barred only in case where the deposit is made with a bank and not a private person. In question number 67, the correct answer is option 2 because the suit filed on the 1st January 2014 is within the limitation because limitation of 3 years commences from 2012. So this is the right answer. From because 2012 the repayment is demanded. Question number 68. Consider the following statements. Statement first, the arbitral tribunal cannot rule out of its own jurisdiction. Statement second, oral arbitration agreement is enforceable. Statement third, the parties may choose mid-arb as the processor for settlement as of their dispute. And statement 4, there must be pre-existing written agreement arbitration for dispute settlement by arbitration. Which of the statement is correct? In question number 68, the correct statement is correct statements are third and fourth statement. They are the correct statement. Third statement is related. The parties may choose mid-arb as the procedure for settlement of the dispute. Statement 4, there must be a pre-existing written agreement of arbitration for dispute settlement by arbitration. Question number 69. Is the statement of law correct that an arbitration cannot decide ex equo et bono? Take the most appropriate answer. Options are: yes, it is always correct. Option 2, no, it is not correct. Option 3, yes, it is correct provided only if the parties have expressly authorized the arbitrator to do so. Yes, provided the parties expressly or impliedly authorize the arbitrator to do so. Here the correct answer is option 3. Yes, it is correct provided only if the parties have expressly authorized the arbitrator to do so. Ex equo et bono means matter to be decided according to the principle of equity rather than by points of law. This Latin maxim more focusing on the equity rather than on law. Now let us see the question number 70. Whether an arbitrator under the Arbitration and Conciliation Act has the power to correct and interpret the award after it has been pronounced. Option first, no, as the arbitrator becomes functus officio. No, the arbitrator does not have the power of review. No, as section 34 of the Arbitration and Conciliation Act prescribes procedure for setting aside the award. And option 4, yes, in terms of section 33 of the Arbitration and Conciliation Act. In question number 70, correct answer is option 4 because section 33 talks about the correction and interpretation of the award of Arbitration Act. Now let us see the question number 71. In execution of a money decree of rupees 1 lakh, the detention of the judgment debtor in civil prison for 3 months may be ordered. A, as one of the modes of the enforcement subject for certain restrictions and conditions. B, if he willfully does not comply with the direction disclosed by affidavit the particulars of his assets. Consider the following statements and choose the correct options. Option first, both A and B are correct, and option second, neither A or B is correct. In this case, Both the options are correct. Both A and B are correct. Question number 72. In a suit for partition of property and for separate possession of a share therein, the civil court having declared the rights of several parties interested in the property. Option A, which is assessed to the payment of revenue to the government, must take over the matter for such partition or separation to be made by the collector. Option second, which is not so assessed to payment of revenue to the government, must examine if the partition or separation can be conveniently made, and for this may issue a commission to make the partition or separation. Option 3, if an examination of the report of the commissioner, the court finds that the property cannot be divided by metes and bounds, it may put it to sale and divide the proceeds thereof. In the above, which of the following options are the correct options? A, B and C are correct. In the given statements, options, the first option is correct, which says that A, B, C and are correct. All of these statements which are provided in question number 72 are correct. Question number 73. When and how a decree can be passed on a compromise in a suit against a minor sued through his guardian? Options are: requires the affidavit of the guardian and the compromise is for the benefit of the minor. Option second, suit against a minor cannot be compromised except with the permission of the guardianship court. And option 3, both parents of the minor must furnish an affidavit stating that they have compromised. And option 4, if the minor signs the compromise deed. In the given options, option first is the correct answer, requires the affidavit of the guardian and the compromise is for the benefit of the minor. Question number 74. In a suit for recovery of possession of a residential premises from the lessee after the determination of the period of lease, on being satisfied that the defendant, with intent to delay the execution of the decree that may be passed against him, is about to abscond from his local jurisdiction limits, the court may call upon the tenant to furnish security for his appearance until satisfaction of the decree. Options are: the above statement is not correct, absolutely correct, partly correct, as order of his nature can be passed only after the judgment is pronounced, partly correct, as such as an order can be passed only where there are areas of electricity bill. In question number 74, the correct answer is option second, absolutely correct. This statement is absolutely correct statement. Now let us see the question number 75. An executing court cannot determine the questions relating to which of the following: discharge of decree, satisfaction of decree, modification of decree, or execution of decree. The execution court cannot determine the questions relating to modification of decree. So option third is the right answer. Question number 76. Which of the following is the most appropriate? The institution of appeal does not by itself operate as stay of the decree appealed against. Option second, the appellate court has the power to stay the execution of the impunged decree. Both first and second are correct. Only one is correct and only second is correct. In question 76, third option, that is both the statements are correct, is the right answer. Question number 77. Rejection of an application for leave to sue forma pauperis is a decree, not a decree, may or may not be a decree depending on facts, none of the above. Question number 77, correct answer is second, not a decree. Forma pauperis is a Latin term meaning in the manner of pauper, allowing a poor person to bring suit without liability for the cost of the suits. Now let us see the question number 78. Legal heirs must always be the legal representative in civil suit. The statement is correct, partly correct, incorrect, none of the above. Answer is incorrect, because according to section 2 subsection 11 of CPC, a legal representative is a person in law who represents the estate of a deceased person. This includes anyone who interferes with the state of a deceased person as well as the person to whom the estate devolves upon the death of the party. Question number 79. When a suit is filed against a minor represented by his guardian, the decree passed in the suit will not operate as res judicata, will operate as res judicata, will not be binding on the minor if he files a suit on the same cause of action within 1 year of becoming major, none of the above. In question number 79, the option second is the right answer, will operate as res judicata. Question number 80. At times, proceedings are adjourned sine die on account of stay. Even after stay is vacated, intimation is not received and proceedings are not taken up. In an attempt to remedy this situation, we consider it appropriate to direct that in all pleading cases where stay against proceedings of a civil or criminal trials is operating, the same will come to an end on expiry of 6 months from today unless in an exceptional case by a speaking orders such stay is extended. This observation was made by the Supreme Court recently in which of the following cases? This observation was made by the Supreme Court in Asian Resurfacing of Road Agency Private Limited versus Central Bureau of Investigation 2018. Question number 81. A partner who retires from a partnership firm, such partner is no longer liable for debts or liabilities of the firm toward the third person from the date of his retirement. Options are: yes, a retiring person is no longer liable because his liability is only till he continues as a partner of the partnership firm because of section 13 of the Partnership Act. Option second, yes, he is not liable because after his retirement from the firm, the other partners no longer can act as the agents of the retiring partners as per section 18 of the Partnership Act. Option 3, a retiring partner is only liable for debt liabilities of the firm to a third person till a public notice is given of his retirement in view of section 32 of the Partnership Act. Liability of the retiring partner will continue unless public notice of the retirement of the retiring partner of the firm is given both by the retiring partner as also by the partnership firm. In this question, correct answer is option 1. Yes, a retiring person is no longer liable because his liability is only till he continues as a partner of the partnership firm because of the section 13 of the Partnership Act. Question number 82. Person is liable as a partner of a partnership firm only if he is a partner by an express written contract. Option: no, a person is liable as a partner by an implied contract provided thereafter the implied contract is got registered before the sub-registrar. Option second, no, a person is liable as a partner even by holding himself out as a partner of the partnership firm, but only to that person who has on the faith of such holding out has given credit to the partnership firm. Option third, a person who holds himself out as a partner will be liable as a partner of the firm only when the third person who deals with the partnership firm has informed a person holding out that he is acting with the firm on the basis of such holding out. Option 4, a person holding out is liable to a third person only if the third person has given a public notice. According to section 82, the question asked about an express written contract, the correct answer is option second. No person is liable as a partner even by holding himself out as a partner of the partnership firm, but only that person who has on the faith of such holding out has given credit to the partnership firm. Question number 83. Is it correct that in a contract of sales of goods under the Sales of Goods Act, if the goods received are not as per the terms of the contract, then the buyer in all cases has no liability to pay for the goods which are received by him from the seller? Option: yes, he is not liable because no buyer can be imposed a liability for receiving contracted goods. Option second, yes, he is not liable till he gives intimation in writing of acceptance. And option third, yes, he is not liable if he has intimated the seller within the reasonable time that the goods have been rejected. And option 4, no, he is liable because of the principle of buyer be aware. Correct answer in question number 83 is option 3rd. Yes, he is not liable because he has intimated to the seller within reasonable time that the goods have been rejected. In a contract of sale of goods under the Sales of Goods Act, there can be stipulations both in the nature of conditions and warranties. Option 1, yes, in a contract of sale there can be stipulations which are both in the nature of conditions and or warranties. Option second, with respect to the sales of goods under the Sales of Goods Act, if the contract is an international contract, only then can the contract contain conditions and warranties. With respect to the sales of goods under the Sales of Goods Act which are in the form of bullion or jewelry, only then can there be both conditions and warranties in the contract of sale of such goods. Conditions and warranties in a contract of sales of goods can both exist provided the warranties are those which are only those written on a stamped agreement duly notarized as per section 85 of the Indian Evidence Act. Here the correct answer is option 1. Yes, in a contract of sale there can be stipulations which are both in nature of conditions and or warranties. Now let us see the question number 86. When the specific goods which are the subject matter of the contract under the Sales of Goods Act have perished prior to the making of the contract, then contract can be enforced against the alternative goods because the contract of sales of goods otherwise valid. Options are: no, the contract of sale of specific goods cannot be enforced because goods have already perished without the knowledge of the seller at the time of the contract, and then the contract of the sale itself is void as per section 7 of the Sales of Goods Act. Option second, though ordinarily the contract of the sale cannot be enforced against alternative goods instead of the contracted goods which have perished, but the alternative goods can be received by the buyer from the seller if the value of the specific good is less than rupees 100. Option third, if the specific goods have perished before making of the contract and this was a fact already known to the buyer but not the seller, then the contract is not valid with respect to the claim of the buyer for alternative goods. Option 4, a contract for sale of specific goods which have perished prior to the entering into the contract for sale will be void and can be enforced against alternative goods only if the buyer has possession of the alternative goods. Here the correct answer is option first. No, the contract of sale of specific goods cannot be enforced because goods have already perished without the knowledge of the seller at the time of the contract, and then the contract of sale itself is void as per section 7 of the Sales of Goods Act. Question number 87. There is no distinction between a sales and agreement to sell under the Sale of Goods Act. Option 1, yes, it is correct because parties must always act in furtherance of the intentions to complete their obligations under agreement to sell. Option 2, there is a distinction between agreement to sell and a sale under the Sale of Goods Act because property title in the goods which are subject matter of the agreement to sell will only pass when the time lapses or conditions are fulfilled, subject to which property in the goods is to be transferred and thereafter the agreement to sell matures into sale. There is option third, there is no difference between a sale and an agreement to sell because both such contracts are automatically unconditional. And option 4, there is no difference between the sale and agreement to sell under the Sale of Goods Act only if such contracts are those with respect to the perishable goods. Here the correct answer is second. There is distinction between the agreement to sell and sale under the Sale of Goods Act because the property title in the goods which are subject matter of the agreement to sell will only pass when the time lapses or conditions are fulfilled, subject to which property in the goods is to be transferred and thereafter the agreement to sell matures into the sale. Question number 88. During investigation by a police officer under the directions of the magistrate on complaint of A, alleging criminal misappropriation of his diamond ring by B, A produces an invoice evidencing his title to the property. The invoice is found during investigation to be fabricated. On closure report, the magistrate took cognizance and summoned A to face trial on the charge of fabricating false evidence. The contentions of A are: the document invoice was not given in judicial proceeding, the police officer has not made a complaint. Here options are both A and B are correct, only A is correct, only B is correct, both A and B are incorrect. These both statements will be incorrect. Option 4 is the right answer. Now let us see the question number 89. A was working in an institution. He withdrew certain amount of money with the permission of the head of the department for disbursing it amongst other employees. However, he took the money home and used it for his urgent need. A month later, he brought the same amount from his home and disbursed it amongst the rightful recipients. He has committed option first, no offense, option second, offense of third, and option third, offense of criminal breach of trust, and option 4, offense of criminal misappropriation of property. Here the option third is the right answer with offense of criminal breach of trust. Criminal breach of trust is given in section 400 of IPC. Section 400 of IPC of criminal breach of trust says that whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged or of any legal contract express or implied which he has made touching the discharge of such trust or willfully suffers any other person so do commits criminal breach of trust. Question number 91. In P. Ratinam versus Union of India 1994, the Supreme Court held that section 309 IPC is unconstitutional. Was this judgment overruled and if so, in which case? Here the correct answer is yes, Srimati Gyankaur versus State of Punjab 1996. Question 92. The word injury under the IPC denotes only physical injury, only physical mental injury, only harm to body and property, harm to body, mind and reputation of property. Here the correct answer is 4. Section 44 of IPC talks about the injury. The word injury denotes any harm whatever illegally caused to any person in body, mind, reputation or property. So the correct option 4 is the correct answer. Question number 93. Which of the following does not constitute secondary evidence? Option 1, a photograph of the original document taken on a smartphone, a copy compared with the original document made by copying machine, a copy transcribed from a copy not compared with the original, oral evidence regarding the context of a document by a person who has seen the original document. Here the correct answer is option 3, a copy transcribed from a copy not compared from the original. This will not constitute secondary evidence. So this is the right answer in the questions asked. Secondary evidence is the evidence that has been reproduced from an original document or substituted from an original item. Section 63 of Indian Evidence Act explains about the secondary evidence. Match the following items: theft, taking without consent, criminal misappropriation of property, only movable property, criminal breach of trust, entrustment of property, cheating. Answer is deception, cheating, D. Question number 95. Fill in the blank. When the question is whether a man is alive or dead and it is shown that he was alive within dash the burden of proving that he is dead on the person who affirms it. Answer is 30 years. Question number 96. Fact under section 3 of the Indian Evidence Act means the truth as proved in the court of law which helps of witnesses, facts as narrated by the client to the lawyer, belief of a person in the existence of certain things, anything, state of things or relation of things capable of being perceived by the senses. This option is the correct answer related to fact. Question number 97. Options are match the two columns: rebuttable presumption, irrebuttable presumption, conclusive proof and proved. Rebuttable presumption, correct answer is A. Court may presume a fact unless it is disproved. Irrebuttable presumption, court shall presume the fact unless it is disproved. Conclusive proof, court shall not permit evidence to the contrary. Proved, court believes it to be exist or considered its existence probable. This is the correct match. Question number 98. A will can be proved at least one attesting witness being examined. Therefore, where both the attesting witnesses have died, the will cannot be proved. Is this statement correct? No. The signatures of the attesting witnesses and the executant can be identified by the person acquainted with signatures of the attesting witness and the executant. Question number 99. In a suit for partition, a memorandum of family settlement is filed, and on this basis the partition suit is decreed. But even after disposal of the suit, the original memorandum of family settlement remains in the file of the partition suit. Then in such situation, whether in a suit for eviction by one of the original co-owner of a tenant of a shop of the joint property which has fallen to the share of that co-owner as per the decree passed on the memorandum of family settlement, can the certified copy of the memorandum of family settlement be filed and proved as a public document in the suit against the tenant? In question number 99, the correct answer will be no, it cannot be, because the original memorandum of family settlement document which exists in the suit for partition which is disposed of is a private document and not public document under section 74 of the Indian Evidence Act. This is the correct answer. Now let us see the question number 100. Power of attorney is presumed to be correct if it is attested by the oath commissioner, if it is executed before and authenticated by a notary public, if it is attested by two witnesses, if it is registered. Here the correct answer is option second, if it is executed before and authenticated by a notary public. Question number 101. A written contract is proved as per section 91 of the Indian Evidence Act. Can the terms thereof be proved to have been altered by a contemporaneous oral agreement by a third party to the written contract? Options are: terms of written contract can never be varied. The oral agreement can be proved to vary the terms of the written contract only if the original written contract is lost or destroyed. The terms of the written contract are only binding between the parties to the documents, but a third party to the written contract can always show contemporaneous oral agreement to vary the terms of the written contract. Option 4. A third party cannot lead evidence to vary the terms of a written contract as he was not a party to the contract. Correct answer is option 3. The terms of the written contract are only binding between the parties to the document, but a third party to the written contract can always show contemporaneous oral agreement to vary the terms of the written contract. Question number 102. A is arrested and detained in custody in a case of murder. The investigation police officer within 24 hours produces the accused before a Metropolitan Magistrate who has no jurisdiction to try the case. Seeking police custody as investigation is not complete. The Metropolitan Magistrate has the power and jurisdiction to: option 1, grant police custody only for 2 days, option 2, grant police custody for 15 days, option 3, discharge the accused, and option 4, refuse to entertain the application as he has no jurisdiction to try the case. In this question, the correct answer is option 2, grant police custody for 15 days. Question number 103. Recording of pre-summoning evidence by the Metropolitan Magistrate in case of alleging cheating may be dispensed with the section 200 CRPC in which one of the following case? Option R. The complaint is made in the form of affidavit. The complaint is made by a Parda Nashin lady. The Metropolitan Magistrate is of the opinion that the ends of justice require so. The complaint is made by a public servant in writing and while acting in discharge of his official duty. In question number 103, correct answer is option 4. The complaint is made by a public servant in writing and while acting in discharge of his official duty. Question number 104. In which one of the following cases did the Supreme Court lay down detailed guidelines with regard to the use of section 451 CRPC, order for custody and disposal of property pending trial in certain cases? Options are: Manjeet Singh vs State of Rajasthan 2012, option 2, Sundar Bhai Ambal Desai vs State of Gujarat 2002, option 3, State of Bengal vs Kailash Chandra Pandey 2004, and option 4, Kailash Chandra Asthana vs State of UP. Here the correct answer is option 2, Sundar Bhai Ambalal Desai vs State of Gujarat 2002. In this case, Supreme Court laid down the detailed guidelines with regard to the use of section 451 of CRPC, which is related to the order for custody and disposal of property pending trial in cases. Question number 105. Autre fois equate principle is related to retrospective operation, double jeopardy, ex post facto loss, and self-incrimination. The correct answer for this is double jeopardy. Autre fois equate is a defendant's plea of stating that he or she has already been tried for and acquitted for the same offense. Therefore, double jeopardy is the correct match to this question. Match the two columns. Section 357 of CRPC. Correct match among the second column will be compensation may be ordered by the court to be paid for fine or otherwise. Section 357A CRPC is related to victim compensation scheme. Section 357B CRPC is related to compensation to be addition to Section 357C CRPC, the last treatment of victims. In which of the following circumstances inquest of the dead body by the magistrate is compulsory? Murder of a child of 17 years, unnatural death of a woman within 7 years of her marriage, death of a married woman in all cases where an old man dies of cancer. Here the correct answer is unnatural death of woman within 7 years of her marriage. What is the duration of sentence of life imprisonment? Here the correct answer is option 1, imprisonment till death. Question number 109. An arrestee's right to consult and be defended by a lawyer flows from which article of the Constitution of India? Correct answer is Article 22. Article 22 talks about the protection against arrest and detention in certain cases. Question number 111. High Court's power of contempt are rooted in the provision of the Constitution of India. Article 226, Article 14, Article 21 and Article 215. Here the correct answer is Article 215. Article 215 declares every High Court to be court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Question number 112. The power to make laws vest in the Parliament and State Legislature by virtue of which provisions of the Constitution of India? Article 245, 7th schedule, Article 246, none of the above. Correct answer is Article 245. Article 245 of the Indian Constitution talks about the extent of laws made by Parliament and by the legislatures of states. It gives Parliament the power to make laws and also gives the legislative body the power to repeal them. Now let us see the question number 113. Can the High Court, while examining the constitutional validity of a statute, declare it ultra vires prospectively? Correct answer is no, it cannot declare them ultra vires prospectively. Question number 114. A High Court judge resigns from his service. An issue arises before the court with regard to the date when he demitted office. The date would be when he tenders his resignation. Option 4 is the right answer. Question number 115. Which of the following propositions of law is most appropriate? Options are: tax requires no quid pro quo. Option 2, tax fee require no quid pro quo. Option 3, both tax and fee required quid pro quo. And option 4, none of the above. Correct answer is option 1, tax require no quid pro quo. Meaning of quid pro quo is favor or advantage granted in return of something. Now let us see the question 116. A contract for construction of an international airport was executed between X and the central government. On behalf of X, the contract is signed by its managing director. Insofar as the central government is concerned, the contract is made in the name of Secretary, Ministry of Civil Aviation. Central government wishes to take the defense that the contract is not binding on it. Which article of the Constitution of India should it take recourse to? Here the correct answer will be Article 299. This is the correct answer because Article 299 clause 1 talks about that all contracts made in exercise of the executive power of the Union or of a state shall be expressed to be made by the President or by the Governor of the state as the case may be, and all such contracts and all assurances of property made in the exercise of that power shall be executed on behalf of the President or the Governor by such persons and in such manner as he may be, direct or otherwise. So option 3 is the correct answer. Question number 117. X demits the office as the Comptroller and Auditor General of India. He has received offers for re-employment from the central and the state governments. What are his options? He can be employed by the central government but not the state government. This is wrong. He can be employed by the state government but not the central government. Wrong. He can be employed by both central and state government. This is also wrong. None of the above is the right answer. He cannot be employed by the state and the central government when he demits the office as the CAG or CAG of the Comptroller and Auditor General of India. Now let us see the question number 118. State government wishes to erect a religious structure. The cabinet explores ways and means of levying a tax for that purpose at the earliest. Can the state government enact an act? No. State government cannot enact such act. Can the state government issue an ordinance? If they cannot enact an act, they cannot also issue ordinance. Can the state government issue an administrative circular? No. Correct answer will be none of the above. Question number 119. Which of the following propositions of law is most appropriate? Right to vote is a fundamental right. Right to vote is a statutory right. Right to vote is both a fundamental and common law right. None of the above. Here the correct answer is right to vote is the statutory right. Question number 120. The word secular was included in the preamble to the Constitution of India. It was included on 3/1/1977. This is the right answer. Option 4 is the right answer. The 3 judges of the Supreme Court justices who were superseded in 1973 were, in 1973, 3 judges were superseded during the emergency era. The correct answer is Justice J.M. Sehlad, Justice A.N. Grover and Justice H.S. Hegde. This is the correct answer. Option 2 is the correct answer. Question number 122. The Constitution of India was adopted by the Constituent Assembly on, this is a very easy answer, 26 November 1949. Now let us see the question number 123. Which of the following is not a money bill? A bill which proposes for the appropriation of monies out of the Consolidated Fund of India. A bill which proposes to exempt income from the tax up to 10 lakh rupees. A bill dealing with the custody of Consolidated Fund. And option 4th, a bill which proposes to give power to Municipal Corporation of Delhi to realize extra fund by way of raising existing vehicle entry fee in Delhi from other states. In the question, it is asked which of the following is not a money bill. So option 4 is not the money bill. That is why this is not the money bill. That is why this is the correct answer. And all the other 3 options are related to money bill. Money bill is given in Article 110 of the Constitution of India. Question number 124. Which of the following is not correct in respect of Article 358 read with Article 359 of the Constitution of India? Article 358 suspends the freedoms guaranteed by Article 19, while Article 359 suspends the enforcement of fundamental rights under Part 3rd except Article 20 and Article 21. Option 2nd. Article 358 suspends the freedoms guaranteed by Article 19 only when proclamation of emergency is on the ground of external aggression or war. Option 3rd. Article 359 suspends enforcement of fundamental rights guaranteed by Article 19 only when the proclamation of emergency is on the ground of war and external aggression. Option 4. Article 358 only suspends freedom guaranteed by Article 19 and Article 359 does not suspend the enforcement of Article 20 and Article 21. In this question, it has been asked which of the following is not correct with respect to the Article 358 and Article 359. In the given options, option 3rd is not correct. Article 350 to Article 360 are related to the provisions of emergency in India. Question number 125. Which of the following is not a fundamental duty as per Article 51A of the Constitution of India? To cherish and follow the noble ideals which inspired our national struggle for freedom. This is obviously the fundamental duty. To develop scientific temper, humanism and the spirit of inquiry and reform. This is also the fundamental duty. To provide for all-round development and growth of children. And option 3rd, to safeguard public property and to abjure violence. This is also the fundamental duty. Option 3rd is not the correct answer because it has been asked which is not a fundamental duty. Question number 126. The expression justice, social, economic and political appears in, it is a very easy question, it appears in the preamble of the Constitution of India. Question number 127. A Hindu who is separated from his father B sells to C 3 houses X, Y and Z representing that A was authorized to transfer the same. Y however does not belong to A, it having been retained by B on partition, but on B's dying A as heir obtains Y. Here can C file a suit requiring A to deliver Y to him? Options are yes if the contract still subsists, B only if A was the authorized owner of Y at the time of entering into the agreement to sell with C. Third, only if A has not leased out the property. And 4, none of the above. In this question, the correct answer is option number 1st, yes if the contract still subsists. Match the columns to identify what passes along with the transfer of a certain kind of property. Option A, machinery attached to earth. Option B, debt or other actionable claim. Option C, money. And option D, house. Here, the first option, machinery attached to earth, comes in the category of movable parts thereof. Option 2, debt or other actionable claim, it comes in the part of securities. Money is related to interest, and house, easement annexed therewith. Question number 129. A fraudulently informs B that A's house is free from encumbrance. B thereupon buys the house. The house is subjected to mortgage. The contract is voidable at the option of B, voidable at the option of either A or B, impossible to perform. The contract will be voidable from the option of B. The first option is the correct answer. Question number 130. The shopkeeper has displayed his goods in glass showcase with the price tag prominently visible. B identifies an item from the showcase for purchase and tells A that he is ready to give the price displayed. A realizes that the item did not have the correct price tag and refuses to sell it at the displayed price. Give the most appropriate answer. Options are: A is bound to sell the item as all conditions of a valid contract are complete. Option second: A is not bound to sell B, has only made an offer to purchase and A has still to accept the offer. And option 3: A is bound to sell as his display of goods in the showcase amounted to offer to sell. And option 4: A is not bound to sell though acceptance was complete. Here the correct answer is option A is not bound to sell as B has only made an offer to purchase and A has still to accept the offer. Question number 131. Whether the consideration under a contract for the contract to be valid can only be exchanged between the parties to the contract and not by or between third person who are not parties to the contract. Option R: consideration can be paid even by third party to a contract. Consideration to a contract cannot be paid by a third party to the contract except when payment is by negotiable instrument. Consideration can be exchanged between third parties to contract but only when third parties are legal heirs of the original parties to the contract. Option 4: consideration can be exchanged between persons who are not parties to the contract if at least some part of the consideration is received between the parties to the contract. In this question, the correct answer is option first: consideration can be paid even by third party to a contract. This is provided from the definition of consideration in Indian Contract Act. Question number 132. Whether a contract in which time for performance of an obligation is not specified is a valid contract. Options are: contract will be void as there is no consensus ad idem as to the time for the performance of the obligation vide section 10 of the Indian Contract Act. Option 2: even if time is not fixed, law will presume that the obligation has to be performed in a reasonable time as provided by section 46 of the Indian Contract Act. Option 3: even if no time period is provided by the contract for performance of an obligation, the contract is valid if it is recorded into registered document. And option 4: even if no time for performance is provided, it is a valid contract provided that the contract is a non-commercial contract only. Question 132. The correct answer is option second. Even if time is not fixed, law will presume that the obligation has to be performed in a reasonable time as provided by the section 46 of the Indian Contract Act. Question number 133. By a contract, there are two sets of promise, with one set of promise being legal and the other set of promises being illegal. In view of the statement, which of the following is correct? Here the correct answer is: there can be such a contract, but the contract will only be for the legal set and not for the illegal set of promise, vide section 57 and 58 of the Indian Contract Act. This is the correct answer because only the legal part will come into effect and the illegal part of the contract will not come into the effect because of the section 57 and 58 of the Indian Contract. Now we will move on to question number 134. A woman cannot be arrested or detained in civil prison in execution of a money decree. Is this a correct statement? Option 1: yes, there is a general rule that a woman cannot be arrested or detained in a civil prison in execution of a money decree. This option is only the right option. There is a general rule in CPC that a woman cannot be arrested or detained in a civil prison in execution of a money decree. Now let us move on to question number 135. Question number 135. A judgment debtor is arrested in execution of a money decree. Will he be discharged from the debt under the concerned money decree on completion of the period of detention? Option 1: no, even on release after undergoing the period of detention, he will still be liable for the payment of the money decree in view of section 58 of CPC. Option 2: yes, he will be discharged from the debt under the concerned money decree. Option 3: yes, he will be discharged from debt if the money decree is less than rupees 1 lakh. And option 4: yes, he will be discharged from the debt even if the decree pertains to the recovery of loan. Here the correct answer is option 1. No, even on the release after undergoing period of detention, he will still be liable for payment under the money decree in view of section 58 of CPC. Section 58 clause 2 of CPC clears that a judgment debtor released from the detention under this section shall not merely by reason of his release be discharged from his debt, but he shall not be liable to be re-arrested under the decree in execution of which he was detained in civil prison. Now let us move to question number 136. Can a person who has not suffered special damage because of public nuisance or wrongful act affecting the public file a suit Option 1, absolutely not. Option 2, yes, provided a plaint is filed by 2 or more persons and leave the court is obtained. Option 3, yes, because everyone is a member of the public and can espouse grievance and seek appropriate relief under Section 38 of the Specific Relief Act. Option 4, yes, only if the plaintiff seeks approval and is granted sanction by the Advocate General of the state. Here the question is asked, can a person who has not suffered special damage because of public nuisance or wrongful act affecting the public file a suit? Correct answer for this is option 2, yes, provided that a plaint is filed by 2 or more persons and leave of the court is obtained. Now let us move to the question number 137. Where a suit plaint seeking relief of possession of an immovable property is rejected under Order 7, Rule 11 CPC, whether filing of a fresh suit is barred? Options are no, filing of a suit is not barred provided fresh suit is filed within the period of limitation. This very option is the correct option for question number 137. This is the right answer. Question number 138. Can a court pass a decree in suit seeking rights in an immovable property where a defendant has transferred his interest and rights in the suit property to a third person without issue of summons or notice to the third person? If yes, whether the decree will be binding against the transferee pendent light? Options are no, notice must be issued to the third person, otherwise decree would not be binding on him. Option 2, decree without notice to a third person is valid and notice summons is not required to be issued to the third person. Option 3, decree will be invalid as it violates principles of natural justice. And option 4, decree will be invalid as a judgment. It is only binding on the parties to the suit and doctrine in personam applies. Correct answer for question number 138 is option 2, decree without notice to third person is valid and notice or summons is not required to be issued to the third person. This is the right answer. Question number 139. Which of the following is not correct regarding section 6 of the SRA? Option 1, the period of limitation for filing suit thereunder is 6 months. Option 2, no suits against the government can be brought under the said section. Option 3, the order or decree passed under the said section is immune from challenge by appeal as well as by review. And option 4, it would be necessary for the plaintiff in such a case to prove the absolute title to the property. Here the correct answer is option 4 because it has been asked which is not correct. This statement is not correct, hence it is the correct answer. Other statements are correct. Which of the following proposition is not correct? The plaintiff is entitled to seek a decree for specific performance of contract or compensation in lieu of specific performance under the Specific Relief Act. If liquidated damages have been provided, the plaintiff cannot seek specific performance. Option 3, the court may grant possession, partition or separate possession to the plaintiff in addition to the specific performance of the contract. Option 4, the court may direct refund of the earnest money or deposit made if specific performance is refused. For question number 140, the correct answer is the second option. If liquidated damages have been provided, the plaintiff cannot seek specific performance. This is the right answer. Now let us move on to the question number 141. A suit for possession of an immovable property based on title by a plaintiff who has been dispossessed can be filed. Option 1, within 6 months of the dispossession as per section 5 of the Specific Relief Act. Option 2, even beyond 6 months and up to period of 12 years as provided in the Article 65 of the Limitation Act when dispossession is of a person who is the title holder of the immovable property. This is the right answer. Related to a suit for possession of an immovable property based on the title by a plaintiff who has been dispossessed can be filed even beyond 6 months and up to 12 years as provided in Article 65 of the Limitation Act when dispossession is of a person who is the title holder of the immovable property. This option is the correct answer. Now let us move to the question number 142. Whether a specific performance of an earlier agreement to sell an immovable property can be granted against a person who has subsequently purchased the subject property. Options are no, once the immovable property which is the subject matter of an agreement to sell is sold by the seller to the third person, the earlier agreement to sell is frustrated. Option 2, a proposed buyer under an agreement to sell can seek a specific performance of a contract to sell an immovable property even if the subsequent purchaser is a purchaser for the value but with notice of the prior agreement to sell. Option 3, only if immovable property which is the subject matter of an agreement to sell is transferred during the pendency of the suit and not before filing of the suit. And option 4, a proposed purchaser under agreement to sell can file a suit against the subsequent purchaser of the property which is the subject matter of the prior agreement to sell, but only if payment is made by the proposed purchaser by means of check or bank draft. And question number 42, Correct answer is option second. A proposed buyer under an agreement to sell can seek a specific performance of a contract to sell an immovable property even if the subsequent purchaser is a purchaser for value but with notice of the prior agreement to sell. Now let us move on to question number 143. Can a suit for declaration be filed without seeking any further relief, although such further relief is available to plaintiff? Options are yes, a suit simply seeking the relief of declaration can be filed without seeking further relief if the plaintiff is a pauper and does not have financial means to pay the court fees for the further relief in addition to the relief declaration. Option second, no, the plaintiff is bound to file a suit for declaration and seek further relief once the further relief is available being claimed in the suit for declaration which is filed. Option third, yes, if the consequential relief is claimed in another suit would not be barred under the law of limitation. And option 4, a suit for declaration without seeking further relief can be filed. Correct answer is option second, no, plaintiff is bound to file a suit for declaration and seek further relief once the further relief is available for being claimed in the suit for declaration which is filed. This is the right answer. Question number 144. Select the correct statement. A suit can be filed to enforce a negative covenant contained in an agreement even if the specific performance cannot be granted, provided that the plaintiff has not failed to perform all his obligations under the agreement. This statement is the correct statement. We have to find a correct statement over here, and this statement, the option first, is the correct statement. So this is the right answer. Now let us move on to the question number 145. Read the following statement. There is a rebuttable presumption that a check bearing a date was made or drawn on such date. It cannot be presumed that the holder of a check is a holder in due course. Option third, there is an irrebuttable presumption that the check was made or drawn for consideration. Select the correct answer. Options are all three of the statements are correct. Option second, only first statement is correct. Option third, the first and the second statement are correct. And option 4, none of the above. Here only first statement is correct, so the option second is the right answer, that there is a rebuttable presumption that the check bearing a date was made or drawn on such date. Now let us move on to question number 146. For cognizance to be taken on the offence of dishonor of check for insufficiency of funds in the account, which of the following are prerequisites? The check must have been presented to the bank within the period of its validity or within 6 months from the date on which it was drawn, whichever is earlier. This statement is the correct statement. Second option, the complaint must prove by independent evidence that the check was issued for discharge of debt or liability. Third option, both the above, and option 4, none of the above. Here the only first statement is the correct statement. The check must have been presented to the bank within the period of its validity or within 6 months from the date on which it was drawn, whichever is earlier. Now let us move on to question number 147. Director of a company is liable for an offence committed by the company under section 138 of NI Act. Option 1, because he is a director. Option 2, if he is a person in charge of and responsible to the company for conduct of business of the company. Option 3, if he is a director and shareholder with at least 5% shares. And option 4, if he is a resident of India. Here the correct answer is option 2, if he is a person in charge of and responsible to the company for conduct of the business of the company. Section 138 of Negotiable Instrument Act is related to the dishonor of check. This is one of the important section in the Negotiable Instrument Act. Now let us move to question number 148. Is the statement of law correct? Implied authority of a partner in a partnership firm exists to selling of all properties of the partnership firm for the purpose of carrying on the business of the partnership firm. Options are yes, since a partner is an agent of all other partners, his action to sell any property of the firm for the purpose of running of the business of a firm is valid and result in transfer of ownership of the property which is transferred. This is not the correct answer. No, a partner has no implied authority to transfer any immovable property of a firm under the implied authority doctrine principles contained in section 19 subsection 2 clause G of the Indian Partnership Act. This is the correct option and also the right answer, because in the given option 2 is the right answer. Now let us move to question number 149. On the dissolution of a partnership firm, if the partner is the first person who will receive his share capital from the assets of the firm. Option first, yes, a partner's right in the assets of the firm is supreme and he is the first paid his share before making payment to anybody else via section 46 of the Partnership Act. This is the incorrect statement. Now let us see the statement second. No, a partner will receive his share capital from the partnership firm on dissolution, but first after the payments of the third party debts of the partnership firm, but before the debts of the partners payable to the partnership firm are paid. This is also the incorrect statement. Now let us move to statement number 3. Share capital of a partner in a partnership firm is paid only after paying the third party debts of the partnership firm and loans repayable to the partners by partnership firm. Yes, this is the correct statement. Statement third is the correct statement. First and foremost, the third party debts are to be paid, then the partners can share the remaining portions with to them. Question number 150. A suit of partnership firm to enforce any type of right of the partnership firm is not maintainable unless the partnership firm is registered under the section 69 of the Partnership Act before the filing of the suit. An unregistered firm cannot sue for any rights, be they contractual or statutory, unless the partnership firm is first registered. This is the incorrect statement. A partnership firm can sue for enforcement of its statutory rights even if the partnership firm is not registered. This is the correct answer. Option second is the correct answer. So this is the last and the final question of the 2017 DJS Higher Judicial Services paper, and thank you for watching the entire video and appreciating our effort. Thank you so much. In the description box there is a link of our Telegram channel. In that channel we share each and every video of ours, and also there are certain discussions which are relevant for the examination are shared in that Telegram group. So thank you so much. Thank you for listening. Thank you for appreciating our effort. Please give us a thumbs up and please like, share and subscribe.